We proceeded now to clause 332 and outline all the subclauses.
All right, go ahead.
Is that clear now, leader? Leader?
Yeah, let's go ahead.
Okay, proceed.
Yeah.
Clause 332, notice to be given for alterations affecting positions of load line. Subclause 6 be amended to read: an owner or master of a ship who fails without reasonable cause to comply with the requirements under subsection 5 commits an offense and is liable on conviction to a fine not less than $2,000 or its equivalent in leons. Clause 334, submersion of load line of foreign ship be renumbered to become clause 333. Clause 333, submersion of load line of foreign ship be approved. Clause 335, deck cargo regulations be renumbered to become clause 334. Clause 334, deck cargo regulations, subclause 1 be amended to read: the minister, on the advice of the administration, may by statutory instrument make regulations in this section referred to as the deck cargo regulations, prescribing requirements to be complied with where cargo is carried in an uncovered space on the deck of a ship to which this part applies. Clause 334, deck cargo regulations. Subclause 4 be amended to read: commits an offense and is liable on conviction to a fine not less than $2,000 or its equivalent in leons. Clause 336, posting up of load line certificate and entry of load line details in ship's logbook be renumbered to become clause 335. Clause 335, posting up of load line certificate and entry of load line details in ship's logbook, subclause 3 be amended to read: the master or owner of a ship, of a Sierra Leonean ship, who fails to comply with the provisions of this section commits an offense and is liable on conviction to a fine not less than $2,000 or its equivalent in leons. Clause 337, contravention of load line regulations and detention of ship be renumbered to become clause 336. Clause 336, contravention of load line regulations and detention of ship be approved. Part 19, carriage of bulk.
Hold on, Honorable Maricon. Hold on, Honorable Maricon. Boss 1 to order 3 of the standing orders. I make the following adjustments in the seating accommodation of MPs. Honorable Joseph Ahmed Kanu move over to the seat earlier occupied by the late Honorable Elagoba. Honorable Festus Lansana move over to the seat now occupied by Honorable Princess Darami. Honorable Princess Darami move over to the seat occupied by Honorable Joseph Ahmed Kanu, effective tomorrow. Is that clear? Are all the honorable members here? Honorable Joseph Ahmed Kanu move over to the seat earlier occupied by Honorable Elagoba. Honorable Joseph Ahmed Kanu move over to the seat earlier occupied by the late Honorable Elagoba. Honorable Festus Lansana move over to the seat now occupied by Honorable Princess Darami. And Honorable Princess Darami will move over to the seat occupied by Honorable Joseph Ahmed Kanu. Proceed, effective tomorrow. Proceed, Honorable Mariko.
Thank you, Mr. Chairman. Part 19, carriers of bulk cargoes. Clause 338, bulk cargo regulations be numbered to become Clause 337. Clause 337, bulk cargo regulations be amended to read: the Minister, on the advice of the administration, may by statutory instruments make regulations relating to the safe carriage and storage of. Clause 339, precautions regarding grain cargoes be numbered to become Clause 338. Clause 338, precautions regarding grain cargoes be approved. Clause 340, offences be renumbered to become Clause 339. Clause 339, offences be amended to read: a person who contravenes this part commits an offence and is liable on conviction to a fine not less than $3,000 or its equivalent in the year. Part 20, dangerous goods. Clause 341, regulations as to dangerous goods be renumbered to become Clause 340. Clause 340, regulations as to dangerous goods, subclause 1, be amended to read: the Minister, on the advice of the administration, may by statutory instruments make regulations as to establish which goods, articles, or materials carried on a ship are dangerous goods in accordance with Chapter 7 of the International Convention for Safety of Life at Sea, 1974, relating to carriage of dangerous goods and to amendments thereto or replacements thereof, and such regulations shall have regard to the International Maritime Dangerous Goods Code, IMDG Code, published by the International Maritime Organization as amended from time to time. Clause 340, regulations as to dangerous goods, subclause 2, be amended to read: without restricting the generality of subsection 1, the Minister, on the advice of the administration, may by regulations prescribe thee. Clause 342, carriage and markings of dangerous goods be renumbered to become Clause 341. Clause 341, carriage and markings of dangerous goods be approved. Clause 343, offences be renumbered to become Clause 342. Clause 342, offences, subclause 1, be amended to read: a person who contravenes this part is guilty of an offence and is liable on conviction to a fine not less than $3,000 or its equivalent in the years. Clause 344, rejection and disposal of dangerous goods by ship be renumbered to become Clause 343. Clause 343, rejection and disposal of dangerous goods by ship be approved. Clause 345, forfeiture of dangerous goods be renumbered to become Clause 344. Clause 344, forfeiture of dangerous goods be approved. Part 21, unsafe ships. Clause 346, interpretation be renumbered to become Clause 345. Clause 345, interpretation be amended by replacing the word undermining with the phrase undermining at the beginning of the fourth line to now read: unsafe ship means a ship that is by reason of the defective condition of its hull, equipment, or machinery, or by reason of undermining, overloading, or improper loading, and any other matter relevant to the safety of the ship, unfit to proceed to sea without danger to human life and environment, having regard to the nature of the services for which it is intended. Clause 347, sending unsafe ship to sea, an offence, be renumbered to become Clause 346. Clause 346, sending an unsafe ship to sea, an offence, subclause 4, be amended to read: the person who contravenes this section commits an offence and is liable on conviction to a fine not less than $3,000 or its equivalent in lieu, or to a term not less than 2 years, or to both such fine and imprisonment. Clause 348, owner's obligation to crew regarding unsafe ship be renumbered to become Clause 347. Clause 347, crew regarding unsafe ship be approved. Clause 349, detention of unsafe ship be renumbered to become Clause 348. Clause 348, detention of unsafe ship be approved. Clause 350, method of detention of unsafe ship be renumbered to become Clause 349. Clause 349, method of detention of unsafe ship, subclause 1, be amended by replacing the word "you ship" with the word "ship" on the third line to now read: Where the executive director has reason to believe a complaint or representation that a ship in a port in Sierra Leone is an unsafe ship, he shall order the ship to be provisionally detained for the purpose of being surveyed. Clause 349, method of subclause 3b be amended by replacing the word detrained with the word detained on the second line to now read, where in his opinion the ship is unsafe, order it to be finally detained either absolutely or until compliance with such conditions with respect to the execution of repairs and with repairs or alterations, or the unloading or reloading of cargo, or the manning of the ship as he thinks necessary for the protection of human life and may vary or add to any such order. Clause 351, supplementary provisions relating to detention and compensation were numbered to become Clause 350. Clause 350, supplementary provisions relating to detention and compensation be approved. Clause 352, power of surveyor regarding detention be numbered to become Clause 351. Clause 351, power of surveyor regarding detention be approved. Clause 353, power to require complaint and to give security of course be renumbered to become Clause 352. Clause 352, power to require complaint and to give security of course, subclause 1, be amended by separating the words the case to be the case on the fourth line to now read. Where a complaint is made to the executive director or a surveyor that a ship is unsafe, the complainant may be required to give security to the satisfaction of the executive director or surveyor as the case may be. Clause 354, survey of ship alleged by seafarer to be unsafe be remembered to become Clause 353. Clause 353, survey of ship alleged by seafarer to be unsafe, subclause 1, be amended by replacing the word proceedings with the word proceeding on the first line and separating the words chief engineer to be chief engineer on the third line to now read. In the proceeding against the seafarer of a ship for an offense of desertion or absence without leave, it is alleged by 1/4, including the chief officer and chief engineer, or if their number exceeds 20, by not less than 5 of the seafarers belonging to the ship that the Clause 353, survey of ship alleged by seafarer to be unsafe, subclause 1b, Roman figure 4, be amended by deleting the number 9 on the second line to now read, shall, if satisfied that the allegation is not groundless before adjudication, cause the ship to be surveyed. Clause 355, appointment of surveyor be renumbered to become Clause 354. Clause 354, appointment of surveyor, subclause 1b, be amended by replacing the word things with the word deems on the 10th line to now read, where a surveyor cannot be obtained without unreasonable expense or delay, or is not in the opinion of the court competent to deal with special circumstances of the case, then an impartial surveyor appointed by the court and having no interest in the ship, her freight or cargo, to survey the ship which is the subject of allegation under section 353 and to answer any questions concerning the ship as the court deems fit to ask. Clause 354, appointment of surveyor, subclause 4 be amended by deleting the word have after the word shall and before the word for on the second line to now read, a person carrying out a survey of a ship under this section shall for the purposes therefore have all the powers of a surveyor. Clause 356, cost of survey be renumbered to become Clause 355. Clause 355, cost of survey be approved. Part 22, Rec. Clause 357, interpretation be renumbered to become Clause 356. Clause 356, interpretation. The definition of the phrase related interest, subparagraph C, be amended by replacing the word conversation with the word conservation at the beginning of the third line to now read. Health of the coastal population and the well-being of the area concerned, including conservation of marine living resources and of wildlife. And Clause 358, appointment of receiver, be renumbered to become clause 357. Clause 357, appointment of receiver, marginal note be amended to read receiver of recs. Clause 357, receiver of recs be amended to read the executive director shall be the receiver of recs. Clause 359, detention by receiver, be renumbered to become clause 358. Clause 358, detention by receiver, marginal note be amended to read delegation by receiver. Clause 358, delegation by receiver be approved. Clause 360, indemnity of receiver be renumbered to become clause 359. Clause 359, indemnity of receiver be approved. Clause 361, administrative measures for removal of rec posing as a be renumbered to become clause 360. Clause 360, administrative measures for removal of rec posing hazard, subclause 2 be amended by separating the words with subsection to be with subsection on the second line to now read. A measure taken by the administration in accordance with subsection 1 shall, clause 362.
Honorable Member. Mr. Speaker, honorable members, it's clear. I therefore move that SO5 to be suspended for the business of the House to.
Any seconder?
I so second.
All those in favor say aye. Aye. Those against say nay. The ayes have it. Proceed.
Clause 362, vessel wrecked, stranded, or distressed in Sierra Leonean or tidal waters, be renumbered to become clause 361. Clause 361, vessel wrecked, stranded, or distressed in Sierra Leonean or tidal waters, subclause 1, be amended by deleting the word in on the third line to now read. Where a vessel is wrecked, stranded, or in distress in Sierra Leonean waters, or on the shores of Sierra Leone, or in tidal waters, the receiver, upon being made acquainted with the circumstances, shall. Clause 361, vessel wrecked, stranded, or distressed, and blacks, let there be a comma between wrecked and stranded. Thank you. Vessel wrecked, stranded, or distressed in Sierra Leonean or tidal waters, subclause 2b, subclause 2 be amended to read the person who, without reasonable excuse, willfully disobeys the direction of a receiver, commits an offense, and is liable to a fine not less than $2,000 or its equivalent in leons. Clause 363, wreck in convention area be renumbered to become clause 362. Clause 362, wreck in convention area be approved. Clause 364, preservation of shipwrecked persons, vessel and cargo be renumbered to become clause 363. Clause 363, preservation of shipwrecked persons, vessel and cargo, subclause 3 be amended to read: a person who refuses, without a reasonable excuse, to comply with the requisition or command under subsection 1, commits an offense and is liable to a fine not less than $2,000 or its equivalent in leons. Clause 365, measures not applicable to pollution in high seas be renumbered to become clause 364. Clause 364, measures not applicable to pollution in high seas, subclause 1, be amended by replacing the word act with the word part on the first line to now read: this part shall not apply to measures taken by the minister under a marine law relating to the intervention on the high seas in pollution in cases of oil pollution by substances other than oil. Clause 364, measures not applicable to pollution in high seas, subclause 2, be amended by replacing the word act with the word part on the first line to now read: this part shall not apply to a Sierra Leonean warship or any other ship owned or operated by the government of Sierra Leone and used for the time being only on government non-commercial service, unless the administration decides otherwise. Clause 364, measures not applicable to pollution in high seas, subclause 3 be amended by replacing the word act with the word part on the second line to now read: where the administration, through the government of Sierra Leone, decides to apply this part to Sierra Leonean warships or other ships described in subsection 2, it shall notify the Secretary General thereof, specifying the terms and conditions of such application. Clause 364, measures not applicable to pollution analysis. Subclause 4 be amended by replacing the word act with the word part on the second line to now read, where the administration has made a notification under subsection 3, the following provisions of this part shall not apply in surrounding waters. Clause 366, report on maritime casualty resulting in wreck, be renumbered to become clause 365. Clause 365, report on maritime casualty resulting in wreck, be approved. Clause 367, determining hazards posed by wreck, be renumbered to become clause 366. Clause 366, determining hazards posed by wreck, subparagraph B, be amended by deleting the word the after the word of and before the word water, and inserting the word the after the word in and before the word area to now read depth of water in the area. Clause 366, determining hazards posed by wreck, subparagraph D, be amended by inserting the word the after the word by and before the word organization on the third line to now read particularly sensitive sea areas identified and as appropriate designated in accordance with guidelines adopted by the organization. Clause 368, duties or measures of persons assisting wreck, distress or strained vessel, be renumbered to become clause 367. Clause 367, duties or measures of persons assisting wreck, distress or strained vessel. Cross-check whether the strained vessel here, whether it's strained or stranded. Whilst I proceed. Clause 367, duties or measures of persons assisting wreck, distressed or strained vessels, which I strongly believe should be stranded vessels because we've had previous provisions before. Stranded vessels, subclause 1, be amended by separating the words in distress to be in distress at the beginning of the second line to now read. A person may where a vessel is wrecked, stranded, or in distress for the purpose of rendering assistance to the vessel, its cargo or apparel, or of saving the life of a person. Clause 367, duties or measures of persons assisting wreck, distress, or stranded vessel. Subclause 3, fine provision be amended to read, commits an offense and is liable on conviction to a fine not less than $2,000 or its equivalent in leons. Clause 369, apprehension of persons plundering, creating disorder, obstructing the preservation of a ship or shipwrecked persons, be renumbered to become clause 368. Clause 368, apprehension of persons plundering, creating disorder, obstructing the preservation of a ship or shipwrecked persons, subclause 2, be amended by separating the words for the to be for the on second line to now read. A receiver may use such force as reasonably necessary for the suppression of plundering, disorder, or obstruction under subsection 1, and may order other person or persons to assist in doing so. Clause 370, appointment of person to give account on oath on board a distress ship, be numbered to become clause 369. Clause 369, appointment of person to give account on oath on board a distress ship, subclause 3 be amended by replacing the word thinks with the word deems on the first line and replacing the word in with the word indicating on the third line, and also replacing the word as with the word was on the third line to now read. The executive director shall, if it is fit, cause a copy of the record to be placed in a conspicuous place in the office of the administration, indicating the area in which the ship was in distress. Clause 369, appointment of person to give account of oath on board the distress ship, subclause 4, be amended by inserting the phrase of this section. Inserting the phrase of this section after the word purposes and before the word have on the second line to now read. The person holding an examination under subsection 1 shall, for the purposes of this section, have all the powers of survey. Clause 371, interfering with wrecked vessel, etc., be renumbered to become clause 370. Clause 370, interfering with the wrecked vessel, etc., subclause 2 be amended to read, the person who contravenes subsection 1 commits an offense and is liable to a fine not less than $2,000 or its equivalent in leons. Clause 370, interfering with wrecked vessel, etc. Subclause 3C be amended to read: committing offense and is liable on conviction to a fine not less than $3,000 its equivalent in leons, or to a term of imprisonment not less than 2 years, or to both such fine and imprisonment. Clause 372, notice of wreck to be given to receiver, being numbered to become clause 371. Clause 371, notice of wreck to be given to receiver, subclause 2 be amended to read: the person who fails or refuses without reasonable cause, proof of which is on him to give notice required under subsection 1, commits an offense and is liable to a fine not less than $2,000 or its equivalent in leons. Clause 373, receiver may take possession of wreck being numbered to become clause 372. Clause 372, receiver may take possession of wreck, subclause 2 be amended to read: a person who fails or refuses without reasonable cause, proof of which is on him, to comply with the notice under subsection 1, commits an offense and is liable to a fine not less than $2,000 or its equivalent in leons. Clause 374, notice of wreck to be given by receiver being numbered to become clause 373. Clause 373, notice of wreck to be given by receiver be approved. Clause 375, delivery of wreck to owner being numbered to become clause 374. Clause 374, delivery of wreck to owner be approved. Clause 376, immediate sale of wreck being numbered to become clause 375. Clause 375, immediate sale of wreck be approved. Clause 377, right to unclaimed wreck be numbered to become clause 376. Clause 376, right to unclaimed wreck be approved. Clause 378, disposal of unclaimed wreck be numbered to become clause 377. Clause 377, disposal of unclaimed wreck be approved. Clause 379, delivery of unclaimed wreck by receiver not to prejudice title be renumbered to become clause 378. Clause 378, delivery of unclaimed wreck by receiver not to prejudice title be approved. Clause 380, breaking up and removal of wreck be renumbered to become clause 379. Clause 379, breaking up and removal of wreck, subclause 5 be amended by deleting the word off on the third line to now read: the administration may, before such removal commences, lay down conditions for such removal only to the extent necessary to ensure that the removal proceeds in a manner consistent with considerations of safety and the protection of the marine environment.
Honorable Chair, may I observe, sir?
Yes, proceed.
Please, my mic is not functioning.
The mobile mic. The mobile mic.
With the leave of Mr.
Yes, please.
Honorable Chairman, colleague, honorable members of Parliament, our legal tendency of this nation, the sovereignty state, is the Leon. We know that this is an international document, and you, as a very reputable solicitor who have served in this country, all agreement to say that the equivalent of, if it is in USD, the equivalent of that, the exchange rate of that day. But today, what I have seen throughout this bill is all USD, dollar. Have we abandoned our own legal tendency that everything in this document is we have dollarized everything? Honorable Chairman, that is my question to this House, sir.
Okay, Chairman, Legislative, any answer?
Thank you very much. Less than $300,000 or its equivalent in leons. Yeah. What does that mean? It makes provision for both local and international. So if it's at international level, we stick with the $3,000, but then if it's not, or its equivalent in leons. So it makes provision for the payment in leons as well. That is my question.
I would have loved to see, Honorable Chair, that wherever we have those fines that is not less than $2,000, to Leo equivalent, Yeah, so that we have our Leo. I feel sad. Yeah, I know. I love to see the green paper in my wallet, but I also value my Leo so much in life that is why I return to Sierra Leone. Thank you.
Thank you very much, Honorable.
Thank you very much, Mr. Chairman. Clause 3H1, liability of cost for locating, marking, and removal of rec bearing number to become clause 380. Clause 380, liability of cost for locating, marking, and removal of rec be approved. Clause 382, exceptions bearing number to become clause 381. Clause 381, exception subclause 1D be amended by replacing the word is with the word are on the fourth line to now read. The International Convention on Civil Liability of Bunker Oil Pollution Damage 2001 as amended, provided that the relevant conventions are applicable and enforced. Clause 383, financial security and compliance certificates bearing number to become clause 382. Clause 382, financial security and compliance certificates, subclause 1, be amended by separating the words gross tonnage to be gross tonnage at the beginning of the second line to now read. A registered owner of a Sierra Leonean ship of 300 gross tonnage and above shall maintain insurance or other financial security such as bank guarantee or similar financial security to cover liability under this act in an amount equal to the limits of liability under subsection 437. Clause 382, financial security and compliance certificate, subclause 8C, be amended by deleting the word of on the second line to now read. The date from which such authority or withdrawal thereof takes effect. Clause 382, financial security and compliance certificate, subclause 13, be amended by deleting the word B on the first line to now read. This act shall, Mr. Black, we have to change the position, shall be not so I think it has to be the other way around. Construed as preventing the administration from relying on information obtained from other states or the International Maritime Organization or other international organizations relating to the financial standing of providers of insurance or financial security, and the administration relying on such information is not relieved of its responsibility as an administration issuing the certificates required by subsection 2. Clause 382, financial security and compliance certificate, subclause 14A, Roman figure 1, be amended by deleting the word of on the fifth line to now read. Invoke the defenses, in brackets, other than the bankruptcy or winding up of the registered owner, brackets closes, that the registered owner will have been entitled to invoke, including limitations under section 437. Clause 384. Application of this part to removal of rec bearing number to become clause 383. Clause 383. Application of this part to removal of rec be approved. Clause 385. Disputes as to title rec bearing number to become clause 384. Clause 384. Disputes as to title rec be approved. Clause 386. Offenses for removal of rec out of jurisdiction bearing number to become clause 385. Clause 385, offenses for removal of rec out of jurisdiction penalty provision be amended to read: commits an offense and is liable on conviction to a fine not less than $3,000 or its equivalent in leons, or imprisonment for a term not less than 2 years, or to both such fine and imprisonment. Clause 387, protection of area around wrecked vessels, bearing number to become clause 386. Clause 386, protection of area around wrecked vessels, subclause 3, be amended to read: a person who, without authority in writing granted by the executive director, enters an area prohibited under subsection 1, whether on the surface or under water, commits an offense and is liable to a fine not less than $3,000 or its equivalent in leons. Clause 388, application for search warrant by receiver bearing number to become clause 387. Clause 387, application for search warrant by receiver be approved. Clause 389, sunken, stranded, wrecked or abandoned vessel, be renumbered to become clause 388. Clause 388, sunken, stranded, wrecked or abandoned vessels, subclause 1, be amended by inserting the phrase and harbor after the word ports and before the word authority on the third line and at the beginning of the sixth line to now read. The administration shall, where a vessel is sunk, stranded, wrecked, or abandoned in a port or harbor under the control of the Sierra Leone Ports and Harbor Authority, which in its opinion is likely to be an obstruction or danger to navigation or to lifeboats engaged in lifeboat service in that port, direct the Sierra Leone Ports and Harbor Authority to. Clause 388, sunken, stranded, wrecked, and or abandoned vessel. Subclause 3 be amended by inserting the phrase and harbor after the word ports and before the word authority on the fourth line to now read. Before property is sold under paragraph B of subsection 1, the owner of the sunk, stranded, wrecked, or abandoned vessel shall be entitled to have the property delivered to him on payment to the Sierra Leone Ports and Harbor Authority. I think should be at its market value. Clause 388, sunken, stranded, wrecked, or abandoned vessel. Subclause 4 be amended by inserting the phrase and harbor after the word ports and before the word authority. On the second line to now read, the value of the property shall be ascertained by agreement between the Sierra Leone Ports and Harbor Authority and the owner, or failing such agreement by some person to be named for the purpose by the executive director. Clause 388, sunken, stranded, wrecked, or abandoned vessel. Subclause 5 be amended by inserting the phrase and harbor after the word ports and before the word authority on the first line to now read. A sum received by the Sierra Leone Ports and Harbor Authority in respect of property under subsection 3 shall, for the purpose of subsection 1, be considered to be proceeds of the sale of such property. Clause 388, sunken, stranded, wrecked, or abandoned vessel. Subclause 6 be amended by inserting the phrase and harbor after the word port and before the word authority at the end of the second line to now read. Where the proceeds of sale of property sold under this section are less than the cost incurred by the Sierra Leone Ports and Harbor Authority, the authority may recover such difference from the owner of the vessel concerned by civil action. Clause 390, wreck of foreign goods subject to same duty be renumbered to become clause 389. Clause 389, wreck of foreign goods subject to same duty, subclause 1 be amended by replacing the word be with the word pay on the second line and deleting the second subject on the third line to now read. Wrecks being foreign goods brought into Sierra Leone shall pay the same duties as those to which such goods will be subject to if they were imported into Sierra Leone. Clause 391, fees payable to receiver be renumbered to become clause 390. Clause 390, fees payable to receiver be approved. Clause 392, rights and remedies of receiver be renumbered to become clause 391. Clause 391, rights and remedies of receiver be approved. Clause 393, limitation to recover costs be renumbered to become clause 392. Clause 392, limitation to recover costs, subclause 1 be amended by deleting the phrase here under on the second line to now read. Rights to recover costs under this act shall be extinguished unless an action is brought within 3 years from the date when the hazard has been determined in accordance with this act. Clause 394, regulations for wrecks by minister be renumbered to become clause 393. Clause 393, regulations for wrecks by minister be amended to read. The minister, on the advice of the authority, may by statutory instruments make regulations providing and in relation to clause 395, dispute settlements be renumbered to become clause 394. Clause 394, dispute settlements be approved. Part 23, salvage. Clause 396, interpretation be renumbered to become clause 395. Clause 395, interpretation, the definition of the word property be amended by replacing the word internationally with the word intentionally. On the second line to now read, property means property not permanently and intentionally attached to the shoreline and includes freight at risk. Clause 397, non-application to platforms and drilling units be renumbered to become Clause 396. Clause 396, non-application to platforms and drilling units be approved. Clause 398, non-application to foreign state-owned vessel be renumbered to become Clause 397. Clause 397, non-application to foreign state-owned vessel be approved. Clause 399, salvage of life be renumbered to become Clause 398. Clause 398, salvage of life be approved. Clause 400, salvage of property be renumbered to become Clause 399. Clause 399, salvage of property be approved. Clause 401, service excluded from salvage remuneration be renumbered to become Clause 400. Clause 400, service excluded from salvage remuneration, subparagraph C, be amended by replacing the word internationally with the word intentional at the beginning of the third line to now read. Where that person has caused the distress giving rise to the salvage either intentional or through negligence. Clause 402, conditions for salvage remuneration be renumbered to become Clause 401. Clause 401, conditions for salvage remuneration be approved. Clause 403, salvage contracts be renumbered to become Clause 402. Clause 402, salvage contracts, subclause 2 be amended by replacing the word matter with the word master on the third line to now read. The master of a Sierra Leonean vessel shall have the authority to conclude contracts for salvage operations on behalf of the owner of the vessels, and the master and the owner of a Sierra Leonean vessel shall have the authority to conclude contracts on behalf of the owner of the property on board the vessel. Clause 402, salvage contract, subclause 3 be amended by deleting the word sections on the third line to now read. This section shall not affect the application of section 403 or the duties to prevent or minimize damage to the environment provided in paragraph B of section 404 and paragraph B of section 406. Clause 401, annulment or modification of contract be renumbered to become Clause 403. Clause 403, annulment or modification of contract be approved. Clause 405, duties of salvo be renumbered to become Clause 404. Clause 404, duties of salvo be approved. Clause 406, duties of owner and master be renumbered to become Clause 405. Clause 405, duties of owner and master, subparagraph B. Subparagraph B be amended by replacing the word with the word without on the first line to now read, to cooperate fully without hindering the course of the salvage operations. Clause 407, power of minister be renumbered to become Clause 406. Clause 406, power of minister, subclause 1 be amended to read the minister on the advice of the administration may. Clause 408, criteria for fixing salvage reward be renumbered to become Clause 407. Clause 407, criteria for fixing salvage reward be approved. Clause 409, responsibility for payment of reward be renumbered to become Clause 408. Clause 408, responsibility for payment of reward, subclause 2, be amended by deleting the word his at the end of the second line to now read. For expediency, a ship owner shall pay the reward on behalf of all interests referred to in subsection 1, subject to retaining the right to be reimbursed by those other interests. Clause 410, quantum of reward be renumbered to become Clause 409. Clause 409, quantum of reward be approved. Clause 411, special compensation be renumbered to become Clause 410. Clause 410, special compensation be approved. Clause 412, services rendered under existing contract be renumbered to become Clause 411. Clause 411, services rendered under existing contract be approved. Clause 413, appointment between salvos, etc. be renumbered to become Clause 412. Clause 412, appointment between salvos, etc. be approved. Clause 414, salvos misconduct be renumbered to become Clause 413. Clause 413, salvos misconduct be approved. Clause 415, salvos maritime lien be renumbered to become Clause 414. Clause 414, salvos maritime lien be approved. Clause 416, duty to provide security be renumbered to become Clause 415. Clause 415, duty to provide security be approved. Clause 417, interim payments be renumbered to become clause 416. Clause 416, interim payments be approved. Clause 418, state-owned cargoes be renumbered to become clause 417. Clause 417, state-owned cargoes be amended by replacing the word generally with the word general at the end of the second line to now read, non-commercial cargoes owned by a state and entitled at the time of salvage operations to sovereign immunity on the general principles of the international law shall not be subject to seizure, arrest, or detention by a legal process or to an in rem proceedings without the express consent of the state owner of such cargo. Clause 419, determination of salvage dispute be renumbered to become clause 418. Clause 418, determination of salvage dispute be approved. Clause 420, humanitarian cargoes be renumbered to become clause 419. Clause 419, humanitarian cargoes be approved. Clause 421, valuation of property salvage be renumbered to become clause 420. Clause 420, valuation of property salvage be approved. Clause 422, detention of property liable to salvage by receiver be renumbered to become clause 421. Clause 421, detention of property liable to salvage by receiver be approved. Clause 423, sale by receiver of detained property be renumbered to become clause 422. Clause 422, sale by receiver of detained property be approved. Clause 424, appointment of salvage by a court of competent jurisdiction be renumbered to become clause 423. Clause 423, appointment of salvage by a court of competent jurisdiction be approved. Clause 425, salvo's right to invest be renumbered to become clause 424. Clause 424, salvo's right to invest be approved. Clause 426, application to government be renumbered to become clause 425. Clause 425, application to government, subclause 4 be amended to read, the minister, on the advice of the administration, may make regulations providing for the application or modification of this part to ships referred into subsection 1 and in relation to services referred to in subsection 2. Clause 427, postal article not subject to salvage be renumbered to become clause 426. Clause 426, postal article not subject to salvage be approved. Clause 428, limitation of action be renumbered to become clause 427. Clause 427, limitation of action be approved. Clause 429, publication of judicial and arbitral award be renumbered to become clause 428. Clause 428, publication of judicial and arbitral award be approved. Part 24, carriage of passengers in ships. Clause 430, regulations respecting carriage of passengers in ships be renumbered to become clause 429. Clause 429, regulations respecting carriage of passengers in ships, subclause 1 be amended to read, the minister, on the advice of the administration, may by statutory instrument make regulations prescribing. Clause 25, limitation and division of liberty. Clause 431, interpretation be renumbered to become clause 430. Clause 430, interpretation, subclause 2 be amended by inserting the phrase on the advice of the administration after the word matters and before the word may on the second line to now read, the minister, for the time being responsible for financial matters on the advice of the administration, may from time to time by statutory instruments specify the amounts which for the purposes of this part are to be taken as the equivalent to any specified number of units of account. Clause 432, persons entitled to limit liability be renumbered to become clause 431. Clause 431, persons entitled to limit liability be approved. Clause 433, claims subject to limitation be renumbered to become clause 432. Clause 432, claims subject to limitation be approved. Clause 434, liability against ship invoking limitation and admission of liability be renumbered to become clause 433. Clause 433, liability against ship invoking limitation and not an admission of liability be approved. Clause 435, claims expected from limitation be renumbered to become clause 434. Clause 434, claims expected from limitation be approved. Clause 436, conduct barring limitation be renumbered to become clause 435. Clause 435, conduct barring limitation be approved. Clause 437, counterclaims be renumbered to become clause 436. Clause 436, counterclaims be approved. Clause 438, limits of calculation be renumbered to become clause 437. Clause 437, limits of calculation be amended by rearranging the lettering and numbering. Clause 439, priorities be renumbered to become clause 438. Clause 438, priorities be approved. Clause 440, measurement of ship's tonnage be renumbered to become clause 439. Clause 439, measurement of ship's tonnage be amended by separating the words gross tonnage to be gross tonnage at the beginning of the second line to now read. For the purpose of this part, a ship's tonnage shall be its gross tonnage as defined in the tonnage regulations and shall be measured in accordance with the said regulations. Clause 441, limitation of liability of port authorities or owners of docks be renumbered to become clause 440. Clause 440, limitation of liability of port authorities or owners of docks, subclause 1, be amended by replacing the word ton with the phrase of the after the word each and before the word tonnage on the 5th line, and deleting the word of after the word or and before the word damage on the 6th line to line. An owner of a dock or canal or a harbor or port authority who may be liable for loss or damage caused to a vessel or goods, merchandise or other things whatsoever on board a vessel shall not be liable to damage beyond any aggregate amount equivalent to 70 units of account for each of the tonnage of the largest Sierra Leonean ship that at the time of such loss or damage occurring is or within a period of 5 years previous thereto has been within the area over which such dock or canal owner or port of harbor authority performs duty or exercises power. Clause 440, limitation of liability of port authorities or owners of docks, subclause 4 be amended to read: for the purpose of this section, the expression owner of a dock or canal includes a person or authority having the control and management of any dock or canal and a ship repairer using the same as the case be. Clause 440, limitation of liability of port authorities or owners of docks, subclause 5, be amended to read: nothing in this section shall impose liability in respect of loss or damage on such owners or authority in any case where no such liability would have existed if this act had not been enacted. Clause 442, limits for passenger claims be renumbered to become clause 441. Clause 441, limits of passenger claims be approved. Clause 443, conversion of account to Sierra Leonean currency be renumbered to become clause 442. Conversion of account to Sierra Leone currency, marginal note be amended to read: conversion of account to Sierra Leone.
Hold on, Honorable. Where the executive members of Jalwa Students Union, are you here? Stand up. Honorable members, I recognize the presence of a cross-section of the Jalwa Students Union executive. Just, not so? Yes, sir. They are here to visit us through their MP, the president of the female caucus. You are heartily welcome to the House of Parliament. Huh? Thank you very much. See that. Proceed.
Thank you, Mr. Chairman, for that short break. Clause 443, conversion of account to Sierra Leone's currency be renumbered to become clause 442. Clause 442, conversion of account to Sierra Leone currency be amended by deleting the phrase of the at the beginning of the third line to read: the accounts referred to in sections 437 and 441 shall be units converted into Sierra Leonean currency according to the value of the According to the value on the date a limitation fund is constituted, payment is made or security or guarantee referred to in section 444 shall have been then deposited. Clause 444, aggregation of claims be renumbered to become clause 443. Clause 443, aggregation of claims be approved. Clause 445, provision of security and release of ship be renumbered to become clause 444. Clause 444, provision of security and release of ship be approved.
You get problem.
Long awaited report. This long awaited bill.
Clause 446, distribution of funds be renumbered to become clause 445. Clause 445, distribution of funds, subclause 2 be amended by replacing the word things with the word limbs on the fifth line to now read. The court may stay proceedings pending in another court in relation pending in another court in relation to the same subject matter, and may proceed in such manner and subject to such regulations as to the exclusion of claimants who do not come in within a certain time and as to payment of costs as the court deems just. Clause 445, distribution of funds, subclause 4 be amended by replacing the word disbursed with the word disbursed on the fifth line to now read. Sums paid for on account of loss or damage in respect whereof the liability of the owners is limited under the provisions of this part, and all costs incurred in relation thereto may be brought into account among part owners of the same ship in the same manner as money disbursed for the one thereof. Clause 445, distribution of funds, subclause 6 be amended by replacing the word things with the word names. On the second line to now read. In making a distribution in accordance with this section, the court may, if it deems fit, postpone the distribution of such part of the amount to be distributed as it considers appropriate, having regard to claims subrogated or otherwise that may be established later. Clause 447, bar to other actions be renumbered to become clause 446. Clause 446, bar to other actions, subclause 1a be amended by inserting the word it after the word if and before the word took on the first line to now read. Where the occurrence took place, or if it took place out of the port at the first port of call thereafter, or clause 448 rules as to division of loss be renumbered to become clause 447. Clause 447 rules as to division of loss be approved. Clause 449 right of contribution be renumbered to become clause 448. Clause 448 right of contribution be amended by replacing the letter A with the word any after the word and before the word other on the second line, and inserting the letter A after the word all and before the word vessels on the third line. To now read. Where loss of life or personal injury is suffered by a person on board a vessel owing to the fault of that vessel and any other vessel, or a vessel and a proportion of the damages is recovered against the owners of one of the vessels which exceeds the proportion in which it was at fault, such owners may recover by way of contribution the amount of the excess from the owners of the other vessel or vessels to the extent to which these vessels were respectively at fault, but no amount shall be so recovered which could not, by reason of statutory or contractual limitation of or exemption from liability, or which could not for other reason have been recovered in the first instance as damages by the persons entitled to sue therefore. Clause 450, recovery of damages from loss of life or by a person on board vessel be renumbered to become clause 449. Clause 449, recovery of damages from loss of life or by a person on board vessel marginal note be amended to read recovery of damages for loss of life or by a person on board vessel. Clause 449. Recovery of damages for loss of life or by a person on board vessel. Subclause 1 be amended to read where loss of life or personal injury is suffered by a person on board a vessel owing to the fault of that vessel and any other vessel and on board a vessel owing to the fault of that vessel and any other vessel, and the proportion of the damages is recovered against the owners of the vessels exceeding the proportion in which it was at fault, the owners may recover by way of contribution the amount of the excess from the owners of the other vessel to the extent to which these vessels were respectively at fault, but no amount shall be so recovered which could not, by reason of statutory or contractual limitation of or exemption from liability, or which could not for other reason have been recovered in the first instance as damages by the persons entitled to sue. Therefore, clause 451, limitations of actions be renumbered to become clause 450. Clause 450, limitations of action, subclause 2 be amended by replacing the word thinks with the word deems. On the third line to now read, a court of competent jurisdiction may, in accordance with the rules of court, extend such period to such extent and on such conditions as it deems fit, and shall, if satisfied that during the period there has not been a reasonable opportunity of arresting the defendantship within the jurisdiction of the court or within the territorial seas of the country to which the plaintiff's ship belongs, or in which the plaintiff resides or has his principal place of business, extend such period to an extent sufficient to give such reasonable opportunity. Part 26, aids to navigation. Clause 452, interpretation be renumbered to become clause 451. Clause 451, interpretation be approved. Clause 453, application of this part be renumbered to become clause 452. Clause 452, application of this part be amended by deleting the phrase "and notwithstanding all the laws in force" on the second line to now read. This part shall not apply notwithstanding all the laws in force in Sierra Leone to aids to navigation and aids. Clause 454, establishment and management be renumbered to become clause 453. Clause 453, establishment and management be approved. Clause 455, executive director's permission to establish aid to navigation be renumbered to become clause 454. Clause 454, executive director's permission to establish aid to navigation be approved. Clause 456, consent to alter aid to navigation be renumbered to become clause 455. Clause 455, consent to alter aid to navigation be approved. Clause 457, functions of administration be renumbered to become clause 456. Clause 456, functions of administration, subclause 4 be amended by inserting the phrase aids to navigation and after the word all and before the word navigational on the second line to now read. Notwithstanding subsections 2 and 3, the administration shall ensure that all aids to navigation and navigational aids are maintained in proper working order. Clause 458, control of private aids to navigation be renumbered to become clause 457. Clause 457, control of private aids to navigation, subclause 1c be amended to read, varies the character of or mode of operating an aid to navigation that is his property or under his control, commits an offense and is liable to a fine not less than $3,000 or its equivalent in millions. Clause 457, control of private aids to... You got it late. Clause 457, control of private aids to navigation, subclause 4, be amended by replacing the word directory with the word director on the first line to now read. The executive director shall, where a person fails without reasonable cause to comply with an order made under subsection 2 or for any reason or notice under subsection 2 cannot be served. Clause 457, control of private aids to navigation, subclause 5, be amended to read, a person who fails without reasonable cause to comply with the order made under subsection 2 commits an offense and is liable to a fine not exceeding $2,000 or its equivalent in millions. Clause 459, publications and updating of aids to navigation be renumbered to become clause 458. Clause 458, publications and updating of aids to navigation be approved. Clause 460, prosecution of offences be renumbered to become clause 459. Clause 459, prosecution of offences, subclause 1C be amended by replacing the word lawfully with the word lawful at the end of the first line to now read: willfully, negligently, or without lawful authority does anything which interferes with an aid so as to hinder the effective use of the aid. Clause 459, prosecution of offences, subclause 1E be amended to read: fails to notify the executive director as soon as practicable after an aid is damaged, destroyed, or fouled, commits an offense, and is liable to a fine not less than $2,000 or its equivalent in leons. To add a comma between damaged and destroyed. Clause 461, detention of the ship in certain circumstances be renumbered to become clause 460. Clause 460, detention of ship in certain circumstances be approved. Clause 462, requirement to pay navigation on aid dues be renumbered to become clause 461. Clause 461, requirement to pay navigational aid dues be approved. Clause 463, penalty for failure to pay navigational aid dues be renumbered to become clause 462. Clause 462, penalty for failure to pay navigational aid dues be approved. Clause 464, fire and light detrimental to navigation be renumbered to become clause 463. Clause 463, fire and light detrimental to navigation subclause 2 be amended to read: where a person to whom notice is given under subsection 1 fails to comply with the notice within the time specified or after complying replaces the fire or light by another fire or light in respect of which the executive director will be entitled to give notice under this section, the person commits an offense and is liable to a fine not less than $2,000 or its equivalent in leons, and to a further fine of $150 or its equivalent in leons for each day or part of day the offense is continued. Clause 465, power of the executive director on failure to extinguish false or unauthorized lights, etc. be renumbered to become clause 464. Clause 464, power of the executive director on failure to extinguish false or unauthorized lights, etc. be approved. Clause 466, removal of obstruction other than wreck. No, clause 466, removal of obstruction other than wreck be renumbered to become clause 465. Clause 465, removal of obstruction other than wreck, so clause 5 be amended by replacing the word things with the word dims on the fifth line to now read: the executive director may dispose of a thing referred to in subsection 3 at such time and in such manner as he deems fit, which is of perishable nature, or the custody of which involves unreasonable expense or inconvenience at such time and in such manner as he thinks fit, notwithstanding that it has not been vested in the administration, and if it is sold, the proceeds shall be applied in payment of expenses incurred by the executive director under this section in relation to the property. Clause 467, regulations on navigational aids be renumbered to become clause 466. Clause 466, regulations on navigational aids, subclause 1 be amended to read: the minister, on the advice of the administration, may, by statutory instruments, make regulations not inconsistent with this act prescribing. Clause 466, regulations on navigational aids, subclause 1G be amended by replacing the word than with the word that on the first line and replacing the word exempt with the word exempted on the second line to now read: determination by the minister that a particular vessel is exempted from the requirements related to payment of navigational aid dues. Part 27, inquiries and investigations into should be marine instead of maintain. Marine casualty and incidents be amended to read pilotage. Part 27, pilotage, clause 468, interpretation be renumbered to become clause 467. Clause 467, interpretation be approved. Clause 469, pilotage area be renumbered to become clause 468. Clause 460, piloting area being amended to read, the Minister, on the advice of the administration, may by statutory instrument establish a pilotage area in a port, place, or the approaches to a port. Clause 470, pilotage authority be renumbered to become clause 469. Clause 469, piloting authority, subclause 2 be amended to read, the Minister, on the advice of the administration, may by statutory instruments appoint a suitably qualified person to be the pilotage authority for SIRIP. Clause 471, compulsory piloting area be renumbered to become clause 470. Clause 470, compulsory piloting area approved. Clause 472, ships to have licensed pilots on board entering compulsory piloting area be renumbered to become clause 471. Clause
Poor man voice, we they
is
bring
liable
out.
to a fine not less than $3,000 or its equivalent in liens. Clause 473, ships to have licensed pilots on board, leaving compulsory pilotage area be renumbered to become clause 472. Clause 472, ships to have licensed pilots on board, leaving compulsory pilotage area be amended to read, where a ship plies in, moves in brackets, other than by warping, brackets closes, or leaves a compulsory piloting area without having a licensed pilot of the area on board, the master of the ship commits an offense and is liable to a fine not less than $3,000 or its equivalent in liens. Clause 474, special circumstances where pilots are required, be renumbered to become clause 473. Clause 473, special circumstances where pilots are required, subclause 1 be amended by separating the words will otherwise to be would otherwise at the beginning of the second line to now read. Where a pilotage authority is of the opinion that there will otherwise be some special risk of danger within a particular pilotage area, the pilotage authority shall require the master of a ship, including an exempted ship it should be, to take on board the ship a pilot acceptable to the pilotage authority. Clause 470, special circumstances where pilots are required, subclause 3, be amended to read, where the master of a ship refuses or fails without reasonable cause to comply with the requirements made under subsection 1, the master of the ship commits an offense and is liable to a fine not less than $3,000 or its equivalent in the yuans. Clause 475, pilotage area, pilotage license and exemption pilotage certificate be renumbered to become clause 474. Clause 474, pilotage license and exemption pilotage certificate, subclause 2 be amended by replacing the word things with the word dims on the third line to now read. The issue and renewal of a pilotage license or a pilotage exemption certificate under this section shall be subject to such conditions, if any, as the administration deems fit and endorses on the license, deems fit and endorses the license or endorses the license or certificate. Clause 476, suspension of pilotage license, be renumbered to become clause 475. Clause 475, suspension of pilotage license, subclause 2 be amended by replacing the word things with the word names on the second line to now read. Where the administration causes an inquiry to be held under subsection 1, it may, as it deems fit, suspend the pilotage license of the licensed pilot in relation to whom the inquiry is to be held, pending the outcome of the inquiry. Clause 475, suspension of pilotage license, subclause 4.
Them one set we more them, but we go shout. Now the poor man voice we they bring out.